Hello, everyone, and welcome back to Wise Credit Management. This is Lesson 7, How to Handle Bad Credit. First, a lot of times it's going to take a long, difficult path in order to recover from bad credit or bad circumstances that you're dealing with. So don't lose heart. Second, this is going to be a pretty long lesson, especially compared to the others, but the information in it, it's dense, it's somewhat difficult to understand because we do get into some legal terminology, but it's worth it. So stick with it until the end because we're going to cover some things that you need to know in terms of your rights and being able to dispute debts, and then who to turn to if you want help. So, a short preview of Lesson 7. We're going to be talking about the debt collection process very simply. You apply for new debt, you spend money for whatever reason, you wind up not paying it back. It winds up in collections and it could wind up as a judgment. Now, disputing debt can work, and we're going to cover that in great detail. And like I said, there's going to be some legalese to take a look at, but we're going to go over that. We're also going to talk about what different professionals do, such as credit counselors, credit repair organizations, and consumer protection attorneys, or what you could call an FCRA lawyer. So, with that having been said, let's get started. And hey, if this is your first time joining us, we're so happy to have you here. This is just a short introduction and a review of the Essentials class. We have several pretty simple goals for the class. Mainly, I want you to understand the principles of wise credit management. My name is Jason Johnson, and while I was an active real estate professional, I focused on first-time homebuyers, many of whom needed help with their credit. Then one day, I believe that God put it on my heart to develop the program that I wish existed for people with credit problems. I know this class isn't the most entertaining, but I believe that it will be the most informative for you. It's completely free to students. It's the most comprehensive program that I know of, and if you pay attention and learn the material, you will be able to build and maintain a good credit score to help you accomplish your goals. I want you to learn how credit really works while being simple and avoiding too much complicated math. It's wisdom that works in the real world. All views expressed are my own and from my experience as a former mortgage professional. Just like your accounting professor won't do your taxes for you, I can teach you how the credit system works, but I can't help you with your credit. On the other hand, what if you do need a professional to help you out? Well, we do have members that can help you. Most real estate professionals can't, or rather shouldn't, try to help you out with your credit because it's just not what they do. You don't really need to understand something as complicated as credit algorithms. You just need to know someone who can understand it. If you need help with getting a good credit score or buying a home, we have a directory of professionals who are ready, willing, and able to help. The directory also has many other types of professionals who you might need along the way. I'm not endorsing any specific company or service, but if that person lists their company on this website, you know they're willing to help you on your journey. And if you don't want to call professionals one by one to explain your situation and see if they can help, you can go to wisecreditprofessionals.com and write one time about the details of your situation, then sit back and let up to 3 of our Wise Credit professionals contact you about how they can help. I show you a lot of screenshots of other companies' websites so that you can see where the information that I get comes from, but the class is considered a new work for education and commentary purposes and therefore does not violate copyright law. Many of the screenshots that I use are directly from the company that calculates your FICO credit score and from the big 3 credit bureaus. We do offer affiliate links, and I would appreciate if you use them, but I also strongly encourage you to use the affiliate links of the other members. When you open accounts with one of these companies, you'll get your own affiliate links offering either cash payments or statement credit, which could add up to over $1,000. And you can see how easy it is to forward the link to this class as well as your own affiliate links to anyone who might need this class. And if you want to see what new opportunities are available since I created this video, you can go to the home page and click on Options and Opportunities for You. This is where you can find our directory to local professionals and not just someone on the phone offering you a rate they can't actually give you. And you can also find affiliate links to other companies that can help you along your journey. Guys, who wishes I would talk just a little bit faster and make the videos just a little bit shorter? Well, I can. Just go to your settings and adjust the playback speed. Guys, thank you so much, and with all that having been said, let's begin. Let's start by mentioning the wealth gap. A lot of this class is focused on helping you get on the right side of the wealth gap by becoming an owner rather than an ower. I tried to make a play on words there. I'm not sure if it came across correctly. But just remember that houses appreciate, cars depreciate, and credit cards create financial slaves. On the wealth gap, you've got haves and have-nots. Now, we discuss this in fairly blunt terms, but the way that I'm explaining it, the have side is people who own homes. They have low debt, they have profitable job skills, prudent spending, and active investing. On the other hand, have-nots oftentimes are renting, they have high debt, they have lower wage job skills, they spend money unwisely, and frankly, they're just trying to make ends meet. So we're trying to get you on the have side rather than the have-not side. And the best way to do that is to pay down your debt, to spend prudently, and to become a homeowner. First, I'd like to mention and I'd like to give a short preview of Lesson 10. Now, when we talk about your credit, and by now at this point in the class you know what your credit score is, or at least you should know what your FICO 8 is. When we talk about what's available for you, FHA is a very popular first-time home buyer program. We've already discussed it lightly, but I want to mention in this particular lesson that you do not need a 700 credit score. We're kind of aiming for that in this class, but really with FHA, to qualify for a mortgage with 10% down, you could do it with as low as a 500 middle score. And to qualify for a 3% down, a 3.5% down program with FHA, you need at least a 580 middle score. But remember, 640 is better. There's a reason that I mentioned 640 a lot, but basically it's for automated underwriting approval. So that's what we're really shooting for with this particular class. So when we compare credit scores to not having a credit score, or rather a no score, you must not have a score on any bureau, which means that you can't have an account, you can't have anything on any of your accounts. If you've accomplished that, that's fine. But if you do have anything on any one of your credit bureaus, you don't qualify for the no score mortgage. You will qualify based on that one credit score, which is probably bad. So I just want to mention that and emphasize that one collection on one bureau, even if it's paid, could stop your mortgage from being approved. Deuteronomy 15:1. At the end of every 7 years, you shall grant a release of debts. Now, if you want to put that a slightly different way, the Jewish Tribal Society had a system of making loans to poor people and desperate people, but they believed that debt, and specifically being in a situation where you needed to borrow money, you were poor or desperate, the debt shouldn't be a lifelong burden. U.S. law, I'll say it mimics that responsibility, that societal belief. We believe that lending is a profitable business and not just for people who are poor or desperate. And we've established statutes of limitations for lawsuits. Now, we're going to get into statute of limitations very deeply here in a little while, but I wanted to mention something to anyone out there who is going through a great deal of financial trouble. In this class, we talk a lot about a cliche character called Charlie, who's really going through a great financial burden. If you are out there and you are really struggling, I want to mention a historical figure that came as kind of a surprise to me. I hadn't heard of him before I started developing this class. So most of you know who Alexander Hamilton is. He was our first Treasury Secretary, and they've recently made a play about him that was very successful. But before him, there was a gentleman named Robert Morris who was helping finance our Revolutionary War. So basically what happened is that Robert Morris declined the Treasury Secretary position because he was in debt from the Revolutionary War and whatever business dealings. So he wound up going to debtor's prison in 1798. Now, keep in mind, he was asked to be the Treasury Secretary for the United States of America, the first one. And a few years later, he wound up in debtor's prison. And business dealings today, we don't send people to prison. Any kind of consumer debt, unless you do it fraudulently, you don't wind up in prison for it. But back then, it was a different story. We actually had debtor's prison. And George Washington, the story is that George Washington went to visit him in jail and quickly determined that we really shouldn't be putting people like this in prison. So Congress very quickly passed a vote, and by one vote, just in case I included this, just in case any of you think that congressional fighting and whatever's going on in our US Congress, just in case you thought that was a new thing, they passed bankruptcy laws to get this guy out of debtor's prison by one vote. They called it the Bankruptcy Act of 1800. So he would have been considered a founding father. He actually went to debtor's prison before they passed the Bankruptcy Act. So if you're in trouble, believe me when I tell you, you are literally not the first one. The first one was a Revolutionary War financier who we actually passed a law to get him out of prison. So don't feel bad if you're going through great difficulty. That's what this class is here for, and I really hope it helps you out. In our country, since then, and more recently, we have passed a lot of laws, and I'm going to explain those very, very surface level, just so that you know that they exist and the generalities of what they do for you. These are your rights. The Fair Debt Collection Practices Act, FDCPA, is an acronym, provides consumer protection from debt collectors. Late payment history and collection accounts can generally only be reported for 7 years. So if you ever wonder where our 7-year law comes from, like I had said before, in Deuteronomy, they have the 7-year law that you will forgive debts after 7 years. Well, U.S. law kind of mimics that. So there are some parallels in our laws and biblical laws. But today, we're going to say that life setbacks happen, whether it's job loss, medical situations, death or divorce, unexpected events, or the foolishness of youth. Things happen, and I don't want that to be a negative result on the rest of your life. In fact, we're going to teach you how to get over that as quickly as possible with as few negative consequences as possible. You're here, we're going to teach you how to take care of things, okay? The negative results of some of life's setbacks are excessive debts, late payments, creditor harassment, collections, and judgments and liens. And really, with this one, maybe I should put an extra bullet point down here called garnishments. Now, in the state of Texas, that's normally not the case, but in a lot of states, they can actually garnish your wages to get their money back after they have a judgment and a lien against you. So these are some very serious negative results that can very badly affect you. Now, there's something else that I wanted to mention here on this next slide in this next series, and I kind of want everyone to be prepared. This is a real story that I heard one day on CBS News. I chose not to actually show the exact story or the woman's name, but if you Google it, you could probably find it. It was, like I said, a CBS News story. There was a woman, she was self-employed. Things weren't going financially well for her, so she gave up her medical benefits. And one day she needed to have emergency surgery for an appendix. That wound up being a $37,000 medical bill. Well, what wound up happening was she couldn't afford her payments, and the hospital sued her. Well, results could be court judgment, debt burden for life. Her family could lose her family business. And the quote that really affected me, this is the quote that I remember, and this is why her story made it onto this particular lesson. She said, "I wish you'd have let me die." Now, keep in mind, she was having a medical emergency. She had every need, every right, so to speak, to go to the hospital, have emergency surgery for her appendix. And because of the great difficulty that she went through trying to repay the debt to the hospital, her family was going to wind up losing pretty much everything that they had because of her, and she felt guilt toward hurting her family because of her medical issue. She said, "I wish you'd have let me die." Now, that deeply affected me, but I want to remind everyone out there, even if you're not going through this, remember, other people might be going through it, and they might be going through it very quietly. In other words, they might not tell you how they actually feel, but debts cause pain, financial burdens, emotional stress. All of that is very real, and I tried to impose that upon gentlemen. That this is a cliche character, just in case you haven't been following along. If this is your first time here, I use stock photos. So I found this guy who's obviously doing something medical over here, but I call him Charlie, and he's basically my guy. I gave him every problem I could think of. So he's really going through it. Job loss, divorce. Goodness, just the divorce in and of itself is gonna be a pain. But he's going through medical issues. He's probably behind on his child support, student loans. Charlie's really going through a great deal of probably emotional pain, physical pain, and he's having problems paying his bills. So I want to take people like Charlie through this particular class and through this lesson and the next lesson, 7 and 8, obviously, to talk to you guys about what you're going through and what your options are. Now, once you know your options, you'll be able to make a more informed decision about what's right for you. So, one thing that I always want to remind you, and we've stressed that through this entire class, joy cometh in the morning. The Federal Trade Commission has certain credit laws. They have the Consumer Protection Act. And within the Consumer Protection Act are more laws, acts. Okay? So you've got Truth in Lending Act, you've got the Fair Debt Collection Practices Act, and you've got the Fair Credit Reporting Act. Let's go through those very quickly one by one because I think that it's important that you know that you have certain rights under the federal law. Truth in Lending Act is it's not really what we're discussing in this particular lesson, but it is one of your rights. It requires a written disclosure with APR. Now that's annual percentage rate. We're not really going to get into that here, but basically it promotes comparison shopping and it helps protect you from unfair credit billing practices. So that is one of your federal rights as a U.S. citizen. The next law that we're going to discuss, the Fair Debt Collection Practices Act. Okay, you can glean from debt collection practices and fair kind of what this law does. Provides consumer protection from abusive, deceptive, and unfair debt collection practices. And we're going to list off, here in the next slide, we're going to list off what collectors can or what they can't do. And it provides civil penalties for violators. This is a very basic list of what debt collectors cannot do. And let's go through them very quickly. Threaten you with harm. They cannot threaten you with physical harm. They cannot use obscene language. They cannot repeatedly call to annoy. Now, there are very specific laws that this particular rule gets very detailed, but if you feel like someone is repeatedly calling you to annoy you, if you're already at that point, Google it and find out what that particular rule entails, because they are probably violating it. They cannot misrepresent the amount that you owe. They cannot misrepresent themselves as attorneys or a government agency. This is probably one of the more common ones, okay? They cannot threaten you with arrest. Remember, we just talked about there is no debtor's prison. Now, if you committed fraud, that's an entirely different issue. But if it's just a debt collection, they can't threaten you with arrest. They cannot collect more fees or interest than the contract allows. In other words, they need to follow the original contract in terms of how much in fees and interest they charge you in addition to what you already owe. They cannot deposit a post-dated check early, and they cannot threaten to illegally take property. So that's a very basic, very general list of all the things that they can and cannot do. Now, one thing that I wanted to mention, you can send a letter that basically says, stop contacting me, okay? But first, please know that they cannot discuss I'll say the matter, but the debt, the situation, whatever you want to call it, with anyone but you. And you can request that they don't contact you at work because you can't take personal calls at work. I know that debt collectors will call you at work, which to me is an automatic violation, but not to the federal law. I believe that they are legally allowed to contact you at work unless you tell them not to, because you cannot take personal calls at work. You can mail them a request not to be contacted. Okay, always send that by certified mail with return receipt requested. We're going to emphasize that in every single piece of correspondence that you send this. You make a copy of whatever correspondence you send them, and you send it with the certified return receipt requested. But remember, if you tell them not to contact you anymore, that leaves the debt collector with no other option than to sue to collect. So you want to be cautious, because if it's within the statute of limitations, that, like I said, they've got no other option, because they're not allowed to contact you anymore trying to collect the debt. Next is the Fair Credit Reporting Act. So this particular law governs credit bureaus, and it establishes consumer rights to fair and accurate credit reports. Now, we're going to go over this in a little bit more detail, but I wanted to take you through and show you. Okay, so this is available publicly. It's on a website. Everything that I show you, none of it is invented. I try to document exactly where this information is for your reference. So we've pulled up the Fair Credit Reporting Act as a document in a PDF file. So you can see a PDF file over here. This is page 25 out of 115, revised September 2018. Establishes rules for reporting adverse information. And if you ever want to know where in federal law your right to have negative information removed from your credit report, where is the 7 years rule? Literally, it's on page 26 of the Fair Credit Reporting Act, or at least it's on page 26 of this PDF. But you can go and look this up. Accounts placed for collection or charged to profit and loss, which antedate the report by more than 7 years. Now, the preceding page, and let's go back to that. Information excluded from credit reports. Okay, so except as authorized under blah 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 blah. This is information excluded from credit reports. Okay, so cases under bankruptcy. That's not really what we're talking about here, but which antedate the report by more than 10 years. So they can't report bankruptcy more than 10 years, or civil suits or judgments or records of arrest made from that date of entry that antedate the report by more than 7 years until the governing statute expired, whichever is the longer period. And paid tax liens from the date of payment, which antedate the report by more than 7 years. So we've got a lot of 7 years here, including accounts placed for collection which antedate the report by more than 7 years. So that's where all of those rules are located. And if you ever really want to reference those in any disputes that you file, that's where you can find it. So I wanted to make sure all of you know that this is actual law and where to find it. So the Fair Credit Reporting Act, once again, late payment history and collection accounts can generally only be reported for 7 years. And there are exceptions. The main exception that we're going to discuss is debt collections that are taken through the civil court in order to get a judgment against you. That's the main exception and the one that we're really trying to avoid for you in this class. Now, the Fair Credit Reporting Act also gives you the right to dispute inaccurate information. Okay, disputed information requires an investigation for accuracy. Now, investigation gets a little bit complicated, but basically you have the right under the Fair Credit Reporting Act to dispute information. I want to emphasize this to you. You don't have to point out exactly what's wrong. They have to investigate it. They have to provide you with the results of that investigation. So when you dispute something, you don't have to prove that whatever you're disputing isn't yours by tracking all of it down and everything. That's on them because they're the ones reporting it. Okay, under the Economic Growth, Regulatory Relief, and Consumer Protection Act. Sorry, guys, this, like I said, this takes a while and it's very dense. But you have the right to place a free credit security freeze on your credit report. And it extends fraud alerts to a length of 1 year. Now, we're going to get into fraud alerts in Lesson 9 under identity theft. Let's spend a minute talking about the Consumer Financial Protection Bureau. So the CFPB is a 21st century agency that helps consumer finance markets work by making rules more effectively, by consistently and fairly enforcing those rules, and by empowering consumers to take more control over their economic lives. Okay, the CFPB can help you, but I'm not going to overly emphasize it because they are not nearly as effective as maybe they should be. But you can definitely file complaints with the CFPB. Basically, what happens is, and frankly, they get 10,000 complaints about services per week. I filed a complaint with them, and I talk about that a little bit in another video. But I've actually filed complaints with them, and the companies respond with boilerplate jargon. In other words, they have a response for every complaint that you can submit, and really all that winds up happening with the CFPB is they keep track of the number of complaints to see whether it's, and I'm not going to speak for them. I'm sure that there's somebody out there who's watching this video right now saying that's not really the way it works. Yeah, but from my point of view as a professional and as a consumer, it seems like they're more concerned with the number of complaints per company. In other words, if they get a lot of complaints about a debt collector, if they get a lot of complaints about a credit bureau not doing the right thing, then they take a look at that. But they don't really seem like they investigate your complaint. So they're going to respond with boilerplate jargon, and that's pretty much where it ends. So it's not as helpful to you as a consumer as my student. However, I strongly encourage you to become one of these 10,000 complaints. If a credit bureau or if a debt collector is doing something wrong, you absolutely should report it. But just keep in mind the chances of them actually doing something to help you as an individual. I'm going to go ahead and say that in my experience, that's a little low. But you may have a completely different experience. You may find they're wonderful and they saved you, and I'm completely wrong. Okay, that's great for you, but I am encouraging you to file a complaint if you come across something that's wrong. Now we're going to talk about the debt collection process. Again, this is going to take a minute, but first, let's say you go out and apply for new debt, credit card. You spend money on that credit card. Second, when you start making payments on that account out of your out of your checking account, that indirectly verifies that the account that you're paying on is yours. So always remember that when you start making payments, that kind of verifies the account is yours. 30 days late gets reported to the credit bureaus as derogatory. So whatever happens, you lose your job, you go through a difficult period, and you start becoming late. That's when it gets reported as a late to the credit bureaus. So now you start getting late fees, higher interest rates, and then they start reporting 60, 90, 120, and then 180 days late. At which point, once you're 180 days late and it doesn't look like they're going to start getting their money back, they're going to close down your account somewhere between here and here. And they're probably going to hire a debt collection company or sell the debt to a debt collection company. So now we've got a collection. The debt collector contacts you. There are certain requirements that they have to meet. They have to contact you and let you know that they're starting the collection process. So then the debt collector reports your account to the credit bureaus. That's separate from what's happened over here already. So now you've got a different account with a different company saying that you owe this money. So now you've kind of got two different accounts against you. Then this could happen, and I really want to emphasize that. The debt collector could sue you before the statute of limitations expires. Now, we're going to talk about that a little bit later on, but every state has different statute of limitations requirements. Here in the state of Texas, the debt collector has 4 years from the date that you stop making payments on the debt to turn around and sue you to get a judgment against you. So that's what the statute of limitations is. But make sure and check that. And certainly, if you have questions, you need to contact a debt collection attorney. So you need to contact an attorney. If you want to talk to a professional member, remember all professional members of my organization of Wise Credit Management, they give you a free consultation. Feel free to contact them and say, hey, is it true that, or Jason said it's 4 years, what is it actually? They'll talk to you for free. So after that, if this is before the statute of limitations expires, and like I said, in the state of Texas, that's 4 years. So let's just say it's 3.5 years since you stopped making payments. The court process, in other words, you go through the court, they sue you, a judge looks at it, and issues a judgment against you. At that point, the debt collector can put a lien on your house. They can put a lien on your bank account. Now, here in the state of Texas, it's this probably won't happen, but in different states, they could garnish your wages. So just make sure and understand that once uh, once we get right here to a judgment, it's going to get difficult for you. And one thing that I would mention, judgments can be indefinite. So again, contact an attorney, but here in the state of Texas, judgments last 10 years, but they can be that 10-year period can get extended another 10 years. So it really could wind up being pretty much an indefinite thing. So I want you guys to know that once it gets to collection, it's something for you to be very concerned about. Also, like I discussed, and I want to mention this specifically, debt collection companies usually have different names than the original creditor. In other words, if you've got a Discover account or a Capital One account and you stop making payments on it, they can either sell or, well, actually, a debt collector can buy the debt or contract with the original creditor just to collect the debt. Basically, you're going to have, you see this guy's general look of surprise. Basically, what I'm saying is they can have a different name. So if you look at your credit report and you see names of companies that you don't recognize, it could be a debt collector. It should say original creditor, Discover or Capital One or whatever. But if you come across a name that you don't recognize, it might just be a collection company for a debt that you actually owe. So don't automatically think that it's some type of identity theft situation. But I also wanted, and down here at the bottom, I always emphasize this. Don't trust debt collectors. Please, just if you can avoid talking to them, don't talk to them. Do everything in writing. But we're going to talk about that here later on. Now we're talking about your options, and specifically how to fix bad credit. Okay, the first one, and this one is the most tricky thing. I didn't even really want to continue talking about time because time is, if it's after 7 years and you haven't been sued within the statute of limitations, after 7 years, this bad credit should fall off. So time can heal this particular wound if you don't get sued for it. Then you can settle the debt, or what you could refer to as paying it. Now that's two different words, and we're going to talk about that. Or you could pay the debt and then dispute it. Okay? Or you could just straight dispute it and say, hey, it's not mine, prove it's mine, that kind of thing. Or you could file bankruptcy and get it discharged through the courts. And we're going to discuss that in detail in lesson 8. So those are a very basic series of options that you have. So with time, always remember, in terms of time, the very least of your worries is an inquiry. The inquiry stays on your credit report for 25 months, but it doesn't affect your credit score after 12 months. Late payments, on the other hand, affect your credit score a great deal when it's currently late. But if you catch up, and if you continue making payments on time, the impact on your credit reduces over time. But down here, I've got it covered up with this circle, but it will continue to drag down your credit score. Just one late payment will continue to drag your credit score down by 20 points from your second year to the 7th year when the late payment finally leaves, when it finally drops off your credit report. So time can heal that particular wound. So like I said, we've got collections. They're complicated. Two basic factors. Is it within the statute of limitations or not? And is it paid or unpaid? Okay, let's start with paid collection accounts. In other words, settled. Once you pay a collection account, the statute of limitations is irrelevant because it's paid. They're not going to sue you for something you've either paid for or settled. Okay, paid means paid in full. Settled means negotiated for less than what you owe. The balance, the outstanding balance, should be reported to your credit report as $0. I want to emphasize to everyone, it still affects your FICO scores. So even an account that's paid, that's settled, even if it has that wonderful notation that says, oh, it's paid in full, it still affects your FICO scores, your mortgage FICO scores. And again, we're going to cover that here in just a little while. So we've got a lot more to cover and more details to cover here in the second half of the class. And it can still be reported to the credit bureaus or simply left on your credit report. And it's supposed to automatically be removed after 7 years from the date of first delinquency. So, all of that having been said, if you've got an outstanding bill, let's just say, hey, I moved and I've got an outstanding utility bill for $200, whatever, but a year later, when I found out about it, when I went to apply for a car, credit card, or whatever got turned down because of this collection account, I called the company and settled with them, And that should be gone, right? No. And when you go to apply for a mortgage, it is still dragging down your credit score by probably 20 points. And that's even if you've gone that 2 years after having paid it. So between years 2 and 7, it's probably still dragging down your credit score by 20 points, which is a whole level of interest rates. And we'll talk about that in lesson 10. Now let's get into some very, very, very difficult situations. Before your state's statute of limitations expires. In other words, if you're here in Texas, and I just keep using Texas as an example, Texas is a huge state, but you get the point. Wherever you are, check your state's statute of limitations. Okay, so let's just say that you've got a bad debt that's within that 4-year period of time. Debt collectors are likely to use the most aggressive tactics to pursue payment. They can do harassing phone calls, lies, deceit, manipulation, threats of lawsuits. I've heard so many difficult things and things that make people either upset or scared. Guys, this is very difficult to deal with, and if you're going through that right now, I get it. My heart goes out to you. So just remember that debt collectors are not people that you want to deal with. You don't ever want to talk to them. Just mail certified, return receipt requested. Now, like I said, I'm going to discuss the statute of limitations, okay? Now, this is for your particular state. This varies by state law, okay? Statute of limitations defines the time period in which a creditor has the right to sue you for payment. Doesn't apply to all debt, okay? So statute of limitations don't protect you from all debt, such as federal student loans, child support, and some other debts that you could wind up having. So there are exceptions that are defined by your state law. I keep saying check your state law. And like I said, feel free to contact an attorney just to ask them what's going on. All of the attorneys that are signed up with Wise Credit Management are they will give you a free consultation. Don't be afraid to just ask, okay? The time period begins from the date of last payment. So basically, and this could vary from state to state. So basically, it's either from the date of last payment or the date that it officially becomes delinquent. There's so much variance in these laws, but it's probably within a 30-day period of time when the statute of limitations begin. So you take this time period when it begins and you add, like I say, here in Texas it's 4 years. That's during the within the statute of limitations to sue you. Now, the last thing, and this is where it gets even trickier, making a payment or even confirming that the debt is yours. If they call you and say, is this your debt? Do you have the intention of paying this debt? You're a good person, right? You're going to pay this debt at some point, right? Oh yeah, yeah, yeah. That could restart the clock, and I'm using a phrase here, but that could restart the statute of limitations and give them another 4 years within which they could sue you. That's how serious this is. So when you talk to somebody on the phone, please don't. And also, if they get you on the phone and have a recording of that conversation, whatever you say, it can and will be used against you. I'll put it like that. Everybody knows that phrase, that they can bring that up in a lawsuit, in a court of law, saying, well, they said that they're going to pay it, so that restarts the clock and that increases the statute of limitations. That's a very, very long and detailed way, and I do understand if you don't quite understand everything that I said, it's okay. But I tried to break it down and be as simple as possible. Now, like we said, the two basic factors: statute of limitations after the statute of limitations has expired, and this only applies to unpaid debt. Because if you paid it, guess what? The statute of limitations, nobody's going to sue you for something that you already paid. So this is for unpaid debt after the statute of limitations has expired. So let's say that it's year 6 here in Texas, okay? Now that debt is called time barred debt, okay? Basically, debt collectors can still contact you and they can still report the debt to credit bureaus. That debt is supposed to automatically be removed after 7 years from the date of first delinquency. Okay, so all of that having been said, and I've got this little picture of a gavel, but with a do not uh, basically a do not sue sign here, that after the statute of limitations has expired, they should not sue you. They should not threaten to sue you. They have no right to sue you to collect this debt. So talk to, if somebody, if it's beyond the statute of limitations and they threaten to sue you, contact a lawyer. See if that's a violation of your rights, because they're not supposed to threaten to do anything they cannot legally do. So that's after the statute of limitations has expired. Now we get to the fun stuff. Like we talked about, you have the federal right to accurate information on your credit report. Okay? If it's not accurate, the appropriate way to handle that is to dispute. Now, the best way to do that is to dispute in writing. Disputing is, and I'm loosely defining it, the process of having credit bureaus update or remove inaccurate information. This involves them investigating to determine the accuracy of the investigation. You file a dispute by writing. That's not the only way, but the correct way according to the JASON class, the Wise Credit Management class, by writing a letter and sending it by certified mail with return receipt. That's so important, and we'll talk about that here in a little while. But if you go to sue the credit bureaus or to sue this company because they're reporting false information, you have to be able to prove that you disputed. You want to include a copy of your credit report with the inaccurate information circled, okay? So find out whatever it is, the amount owed, the time limit, if it's beyond the statute of limit, if it's beyond the point, beyond the 7 years, which they should not be reporting it after, circle that. The date of last payment is the way that you would handle that. A copy of your social security card, a copy of your government ID. Sometimes you need to include a bill. Read the fine print on with regard to whatever they need you to include, because they will reject your dispute just because you didn't include everything that they require that you include with your dispute. So make sure and do all of this right, okay? And one thing that I want to mention, and I think I'm going to mention this a couple of times, disputing it online or over the phone can get the same result. So, absolutely. And when I first started, there was something on my credit that I disputed by phone, and it actually did come off within that 30-day time period. Because it wasn't mine. But I wanted to find out whether or not I could just call them and get the dispute, and it happened, and it came off my credit report, and I haven't seen or heard from it since. But the thing is, when you dispute online or over the phone, you lose the legal right to sue. And again, I'm not a lawyer, talk to a lawyer, but for educational purposes, in theory, you lose the right to sue because it wasn't disputed in writing. So, always dispute stuff in writing unless you're me and you just want to find out what happens. So, and I was perfectly prepared to, at that point in time, I wasn't really worried about how long it took. I just wanted to find out if calling and disputing on the phone would work. It did for me. So if you want to try that, you feel free. This is a sample letter on the FTC website. So you can go to consumer.ftc.gov, and then bunch of numbers over here if you can read that, but just Google it. Sample letter disputing errors your credit report. Just Google it. You'll find on the FTC's website this sample letter. Okay, your name, your address, the date, the company's name, the address, the date, dear sir or madam. Okay, so right here, what you want to do is dispute it to the credit bureau, and you might want to dispute it to that particular company. So you might wind up sending 2 letters. Or if you want to dispute to all the credit bureaus, that's 3 letters plus the company that is that you're disputing the information with, that's reporting it. So that could be 4 letters, 4 certified letters return receipt requested. I'm writing to dispute the following information on my file. I have circled the items I dispute on the attached copy of the report that I received. This item, and make sure and identify it as well as circle it on the report, but identify it with the account number, is inaccurate or incomplete, and describe what's inaccurate and complete and why. And I'm requesting the account the item be removed or to do whatever to correct it. Enclosed are copies of, and like we said, you're going to need to include your the copy of your credit report. And if you paid it, if you're disputing the idea that it isn't paid, you can include a copy of whatever payment method that you used, a receipt, whatever, to just get them to update that it's paid. But usually you're going to be using this particular letter to get something completely removed. Okay, so that's a long way around to explaining that this is a free template offered by the federal government, the same people that basically enforce your legal rights. They give you a letter that you can just insert your own information and send the dispute off yourself. You don't necessarily need anyone's help to do this. Like I said, this takes a while to explain. It's gonna go quicker here in a few minutes, but the Bureau will process your dispute by assigning a dispute code, and that gets complicated. We're not gonna go over that. And begin to verify the account by conducting a reasonable investigation. Investigations usually include contacting the company, reporting the information, and asking them for documents to verify its accuracy. Doing a proper investigation takes a person. Remember, it takes a person who's getting paycheck, and it's therefore an expense. Well, credit bureaus see disputes as an expense and usually do the least amount of work possible to maintain compliance with the Fair Credit Reporting Act. The credit bureau is required to complete the investigation within 30 to 45 days and mail you the results. You can request, you have the legal right to request a reinvestigation if you don't get the results that you want, but reinvestigations get more difficult to obtain because the credit bureau can dismiss it as a frivolous dispute. So there's a lot of more complicated details to unpack. But frankly, at this point, I'm going to suggest, if you want to get deeper into all of this, I have it's called DIY disputing. It's an advanced class. In other words, after you've already graduated from this class, on the website, you wind up, obviously you have to be signed in. You have to create an account. You go through and you take the quiz, and it's a very easy quiz. The quiz is just to emphasize main points. Then you'll have access to, among others, do-it-yourself disputing, in which I get even more in depth in this, and we kind of skip all of these are all your rights, that part of it. But I get very detailed in how to go through all of this. So if you want to, that's available for you. One thing that I do want to mention, when you're going through the dispute process, keep this in the front of your mind. If you dispute an account before the statute of limitations has expired, the debt collector must spend time gathering all the documents necessary to validate the debt, which can after that, they can use that in a lawsuit. So in other words, the way that it was explained to me by a debt collector, within the statute of limitations, I can still sue you. You're asking me to get all of the documents that I'm going to have to show a judge in order to get a judgment issued against you. So I'm going to go around gathering all these documents from the original creditor and then send them to you. What's to stop me from taking the next step and going ahead and filing the fee and suing you in court? It might make it more likely that you could get sued for this particular debt if you dispute within the statute of limitations. So always consider these disputes, take them very seriously, because if you dispute within the statute of limitations, like I said, the debt collector is going to go around getting all the documents necessary to validate the debt that they could use in a lawsuit. And one more thing that I want to mention, this is also very important. Like I said, this class is very in-depth and it's very detailed. It's got a lot of information packed in. Even if the debt gets removed from your credit report, they could still sue you. So getting the debt removed from your credit report, even if you go through all the process and all the steps and you pull off a magic act and you're able to get that debt removed from your credit report within the statute of limitations, you could still be sued. You still owe the money. It's just that it's not being reported to your credit report anymore because, and there's advanced disputing options that you can use. Sometimes they work, so you can use those to get them off of your credit report. But that's not going to be a reason for a judge to sit there and say, yeah, but that's not going to stop a judge from looking at you and saying, yeah, but you still owe this debt. Even if it's not reported to the credit bureaus anymore, you still owe it, and it's within the statute of limitations, and therefore I'm issuing a judgment against you. All of that, like I said, this is complicated. Now, remember, I am not a lawyer or giving legal advice. This class is for education. I'm trying to be a lot more like a college professor than any type of a practicing professional of anything. But let's take a look at the law yourself, and you can decide for yourself. So you can read this particular case. You can go to case law, fine law, all of this, or you can just Google Haddad versus Alexander Zilimansky Danner, and forgive me if you ever watch this and your name is this. I'm sorry, I'm not going to butcher your name. So, Mr. Haddad disputed a debt. Basically, what he disputed was a $50 fee that eventually led to the collection. He didn't dispute the collection, he disputed the fee. The debt collector only verified Mr. Haddad's vital information but did not send him an itemized statement detailing each charge, including the $50 in dispute. Okay, before we go on, Mr. Haddad was ruled against before he was ruled for. He went through several years of this over $50. Okay, I just want to emphasize that it took him a lot of time and a lot of effort. After several courts weighed in, the burden of verification, so in other words, what a debt collector has to do to verify the debt, was increased to include the date and nature of the transaction that led to the debt. Okay, now we're going to go over here. The date and nature that led to the debt, such as the purchase on a particular date, a missed rental payment for a specific month, a fee for a particular service provided at a specified time, or a fine for a particular offense assessed on a certain date, which is the $50 over here. So, a debt collector has to provide the details about the debt in dispute and not just verify that, oh yeah, it's Mr. Haddad with this birth date and this social security number, therefore the account's verified. No, they have to go much deeper into that. That's going to help you out, and we'll discuss that here in a minute, and we'll discuss that in great detail in do-it-yourself disputing. Ah, goodness. Now, for those of you who have been following the class, you know that I like to bust myths, but I'm changing it up. Instead of Mythbusters, we're doing fake or fact. Okay? Can you buy a special dispute letter? Now, I'm referring to Lexington Law's website. Lexington Law is a credit repair firm, they're a national firm. On the other hand, here recently, as I'm filming this, they've recently encountered some legal troubles. So I'm not particularly sure whether or not when you're watching this, whether they'll still be around or how they'll be operating. But they did issue a statement on a 609 letter, and I'll call that a special dispute letter. Just to give you a point of reference, if you are taking this class and never got on YouTube and looked for disputing or something like that, there are people out there selling special dispute letters. And I'm specifically citing the 609 letter. I'm trying not to call out the particular company or the particular individual selling this letter. I'm just relaying to you the facts as I see them. I am not getting into a fight with this particular individual or this company. It's just that I want to point out to my students, this gentleman has the right to say whatever he wants to say on YouTube, and I have the right to show you contravening evidence to the contrary. So, there is a 609 letter going around that's kind of like a special dispute letter. An example of a 609 letter would say something like, as per section 609, I am entitled to see the source of the information, which is the original contract that contains my signature. Now, I'm trying to shorten this class, but let me ask you, how many of you have initiated a debt that contains your signature within the past 10 years? Uh, a credit card, do they even take your signature anymore? It's kind of like electronic verified. But this particular 609 letter seller constantly says, well, you have to have a wet signature. Now, let's refer to the actual law itself. Okay, and I'm going to do this the very simple way. We are going to search the Fair Credit Reporting Act, all 115 pages of it. Remember, it's a PDF. Most of you are very familiar with what I'm doing here. I'm searching for the word, and I don't know if you can see it there, but this is the word wet. If you have seen these particular videos, you'll know what I'm talking about. Wet does not appear in the Fair Credit Reporting Act. Nowhere is it required that you be shown a wet signature. But to be more vague, let's search for the word signature. Fair Credit Reporting Act, I'm searching for signature. Fair Credit Reporting Act. There is no reference, there's no word in the Fair Credit Reporting Act that is the word signature. You, in this particular case, what I'm articulating to you is that not only in section 609 of the Fair Credit Reporting Act, it doesn't mention anything about a wet signature requirement. The entire law doesn't say anything about having a wet signature. Now, let's move on. Does a 609 letter really improve my credit report? Lexington Law came to the same conclusion that I hope you've come to after you've taken a look at the law, all 115 pages, that it takes you approximately 10 seconds to hit Control Find and search for the word signature. The flaw in the 609 letter theory is that the FCRA does not require credit bureaus to keep or provide signed contracts or proof of debts, meaning that the information could still be found valid. So when everyone is telling you something, but the actual law says something different, what I want is for you to use your own judgment. If you want to buy a 609 letter, go for it. That's entirely up to you. But my students, I want you guys to understand what I'm telling you. Just think about it. If you want it to be true, therefore you believe it. before you decide to do anything like that, if there's a special dispute letter that you want, ask yourself if someone is trying to sell you something that you want to be true, but your own eyes tell you different. Also, be very careful. Like I said, I take this very seriously. This is legal stuff that could affect the rest of your life. We talked about a woman who said that she wished she had died rather than having to deal with all this. This is very real. Be very careful not to commit perjury. So let me take you through an imaginary scenario, and there's a lot of things that have to happen between these three statements. But let's just say that you send a 609 letter and say, the debt is not mine because you don't have my original signature. The debt collector responds saying, we verified by the payment ledger that I say he, but this person made payments from their bank account, and they can give your bank account number for several years and then stopped. Whatever caused you to stop is irrelevant. Well, I went through hard times. Okay, that's fine. But we're not here to discuss that. We're here because you sued these people saying that they're violating your rights to have your debt validated. It shouldn't be validated because they don't have your original signature. But that's not a requirement in the FCRA. And furthermore, a judge who went to law school, practiced law, has to deal with stuff like this, even if it's a small claims court judge. I know these people. I've had to deal with them on rental disputes, we'll call it that, to evict people. Good old boy judge is going to look at you and say, do you really expect me to believe the debt isn't yours? Why did you make payments on it? What I'm kind of getting around to is that you are one step away from answering this question and committing perjury, but it's not mine. Do you really expect the judge to believe that? So that's where it can get very, very, very serious for you. You start sending these letters that aren't appropriate or have no legal basis within the FCRA. And then you start thinking that because they didn't verify that your original signature is somewhere, because it probably doesn't exist anyway, you did it online on an app, a judge is going to look at you and say, yeah, but that's not the way the real world works. And I don't want any of my students to get so deep into this that they wind up perjuring themselves over something that someone sold them. So that's this particular class. Like I said, I am protected by not only the First Amendment, but also copyright law, which allows me to present other people's works within my own work. And frankly, if the people who sell 609 letters want to sue me or have any problem with what I'm presenting to my students, uh, let's take it to a judge and see what a judge has to say. So my students will know the truth. Moving on, we're going to talk about locking your credit reports in lesson 9. But when you start disputing things, the first thing I want you to do is consider locking your credit reports. Uh, when you start disputing inquiries, especially, locking your credit file with the bureaus is a really good way to start, because the three major credit bureaus won't be able to verify the information in that you dispute with each other. They like to exchange information, and frankly, some of these bureaus, the lesser known ones, some of these bureaus actually own each other. So they exchange information. Locking the bureaus keeps them from exchanging information. And we're going to talk more about this in lesson 9. But and when you're disputing, I suggest that you lock your credit reports. I also suggest that you clear any old addresses off your credit report. If it's an address over 2 years ago, uh, that that's not really something that you need on your credit report. Um, The reason that I mention all of this, your old addresses could very easily wind up being mismatched with information that is on someone's credit that is actually living there. So you moved out and a new person moved in. You don't want whatever credit they have or whatever bad credit they have. So a lot of time credit bureaus try to match addresses from different accounts, and you wind up having to dispute them. But if they can match this address with that address with your credit report, then they can use that as a reason to verify without actually investigating. Okay, disputing inquiries. So when you dispute inquiries, because they reduce your credit score, remember it only reduces your credit score for the first 12 months. But some companies do reject applicants based on recent inquiries. Well, if you've been through a situation where, and one of my pet peeves with car companies is that they run a bunch of hard inquiries. Well, what you can do is dispute those hard inquiries. When you apply, they'll do a hard pull or a hard inquiry on your credit report. That's one. But if they keep doing that, if they keep shopping your credit around to different companies, it can result in more inquiries than is necessary. And the major credit bureaus, like I said, they use other bureaus to verify your identity when you apply. So when you start disputing inquiries, like I said, it's a common problem when you go for a car loan. When you start disputing those, you're going to want to lock your credit reports, and you're going to lock certain companies. We're going to discuss that in lesson 9, which ones to lock. So you're not quite done with wise credit management yet. Don't just skip ahead to DIY disputing. But one thing that I always want you to remember, once you've locked all these credit reports and everything and then start disputing, it's fine to go ahead and dispute those, especially if you didn't actually apply. But here's the thing, if you did actually apply and get a credit card or a loan, you're approved for that. You've got that. It's a loan that's outstanding, but you dispute the inquiry. It's like saying you didn't apply for that loan or that credit card. In other words, you're calling fraud on a company that gave you a loan. Now, very likely, I mean, it's very likely that they'll shut down your credit card. Oh, you're calling fraud? Well, fine, we'll take the inquiry off, but we're also going to shut down your account. So just be careful not to dispute any inquiry on an account that you have open, or on a company that you want to do business with in the future, because they might flag your social security number as potentially fraudulent and never approve you again. Disputing late payments. Remember, late payments stay on your credit report and affect you for 7 years. Now, one thing that I always want to suggest, and this is just the easiest way to do it. In fact, on a Facebook group, someone asked a question about getting a creditor to remove a late payment. How do you dispute it? You know what I told them? I responded to them. Nobody else had responded yet. So I said, look, give that company a call and ask them to remove it. Start there. Just call them and say, hey, I've caught up with you guys. I'm sorry. Can you please forgive this for me? Most lenders have a policy to remove late payments from your credit history after a certain length of time. Usually, this will work with one late payment, okay? If the account's been closed, you can dispute the entire account. In other words, not having one late payment, but having the entire account removed. And if it's been closed, chances are it's not helping your credit very much in the first place, so getting it off there entirely probably won't hurt you very much. And if you have late payments on your student loan, a credit repair guy that I'm personal acquaintances with, he put out a video talking about this. That's where this particular piece of information came from. That if you've got student loan payments and you've got a late, bring the loan current for long enough that the lender removes the late payments before you refinance. Always remember, bring that student loan debt current and then and get the late payment removed on an open and active loan. That way it expunges all of your late payments off of your credit report. Then if you want to refinance your student loan, you can. So I get my information from a lot of different places. When you're dealing with disputing collections, now there are many different types of collection accounts: medical, credit cards, auto loans, utilities. There are many different circumstances. It could legitimately not be your account. It could be co-signed for by the wrong person. Company sent the last bill to the wrong address. Like, guys, there's so many different things that could have happened. Just keep your eyes on the prize, okay? Your objective is to get the bad information off your credit report. Please don't take this too far and get too emotionally involved. I know if someone's lying about you, that's a personal thing. I mean, that's pretty bad. But all you really want is to get them to report the accurate information. And really, a big company with a million credit cards, they make mistakes. They're just people sitting in an office with a computer, and they transposed a digit on your social security number, on your address, on your date of birth. Accidents happen, just dispute it, get rid of it, and move on. Don't make it personal. They sure didn't. And nobody at that company is going to stay up late at night fuming about you. But it could cause you stress and you to lose sleep being upset with them. So just don't take it personal. Get it off your credit report and keep trucking. Now remember, this whole class I've been telling you that you have the right to an accurate credit report. Now there are two different types of disputes, and we're going to cover these in great detail in do-it-yourself disputing. Factual disputing is a method that calls into question the accuracy of the collection account. Compliance disputing points out any discrepancies between the actual information in the file and the information that's required by Metro 2 standards. So in other words, compliance disputing says, hey, you're not reporting this in compliance with your own rules. Factual disputing says, hey, this information isn't right, prove it's right. Those are the two main types of disputes that you can use. And like I said, we'll cover those in greater detail later on. When you're dealing with, and like we talked about earlier, when you're dealing with paid collection accounts, in other words, settled, it still affects your FICO mortgage scores. Can still be reported to credit bureaus or simply left on your report. It should be reported with a zero balance, but it can still be reported. And it's supposed to automatically come off after 7 years. Now, you can dispute these accounts for various reasons and attempt to have them removed. In other words, you can settle the account and then try to dispute it off. Now, the basic rationale behind this is a company might just get lazy and say, "Hey, we've gotten all the money that we're going to get out of this person. It's a waste of time to keep validating and verifying this debt." So they let it go and it comes off your account. That's what I would refer to as paid and disputed. That would be a very realistic way to get things off your credit report. Your mortgage approval might require you to pay outstanding collection accounts. Mortgage companies usually won't approve a loan if there are active disputes. So don't dispute an account and then go apply for a mortgage. Wait until the dispute is either verified or taken off. So basically, if there's an active dispute, you've got to wait for that process to take place before you can go and get approved for a mortgage. And remember, paid collection accounts. I keep emphasizing that they affect mortgage FICO scores. Okay, now let's take about 5 minutes to discuss exactly what happens here. Let's start with FICO 9 and 10. Okay, these are not, FICO 10 can be used as a mortgage score, so it's important to mention. Paying third-party collections could improve your scores. However, with FICO 8 and older, in other words, your mortgage scores, Paid collection accounts do not have a positive impact on the score. Whether they're paid or not does not matter to your score. However, there's another caveat. Third-party collections affect your score whether they're paid or not, but original creditor reporting your balance as a collection. In other words, it's called a first-party collection. Uh, I've personally just I've personally seen Bank of America continue to report a bad debt, in other words, an outstanding credit card to someone's account all 7 years. And I'm sitting here kind of looking at it thinking, what's the point of continuing to report this as late? I think that they continued to report it 180 days late for the entire 7 years. And I went and looked it up. I actually had to do research because of this particular account. I went and looked it up, and what winds up happening is that when you're dealing with first party collections, the company can continue to report your debt as late. In other words, 180 days or more late, 7 years late. And that will affect your credit utilization. So, in other words, it makes your utilization worse. So, if you pay, and I say reduces utilization, we're talking about if you pay this account, it'll reduce your utilization and therefore could help your mortgage FICO scores if it's a first party collection. Now, if that sounds complicated, don't worry. Uh, don't be afraid to contact one of the professionals and talk to them about it and see what they think, okay? Always a free consultation, but I wanted to specifically mention all of this. I feel the responsibility to mention everything that I know because I wanted this to be a very comprehensive program, and I feel like I've done that. So, here's the settlement process. If you're going to settle with a debt collector, they'll usually contact you with a settlement offer. Usually it's between 40 and 6%, 60% of the balance due. You can negotiate that down, but whether or not they'll take less is up to them. You can make payments as part of the settlement. Also, I want to mention any amount less than the full amount is considered taxable by the IRS, and you should get a 1099 miscellaneous. In this particular circumstance, please contact a tax professional. Now, let me emphasize that. Think this through. Let's just say, for example, that you owe $10,000 on a Bank of America account. And to get that account off of your credit report because it's still affecting your debt utilization, you go to them and you say, hey, will you accept $4,000? That's 40%. Well, if they accept that, they are basically forgiving you of debt. It's a debt forgiveness of $6,000. That $6,000 gets reported with this 1099 miscellaneous. That counts as taxable income. Now, I am not a tax professional, although when I was at Baylor, I did work for H&R Block. I'm not sure if I can, yeah, I'm pretty sure I can just say I worked for H&R Block for 2 tax seasons. I'm not a CPA or anything like that. Please, please, please don't take what I'm saying as professional advice. I'm just telling you the way that it works. This is the way that things work in the real world. It sounds good to get 40% off your debt, right? But the 60% gets reported as taxable income. Now, let's just game this out. Let's say that you went through some very hard times and it's been a few years and you want to get this off of your credit report. Well, if you've got an extra 4 grand to pay this off so that you can buy a house, you're probably doing okay in life. You're probably making more money than you did when you defaulted. So you're going to wind up having income and paying taxes. Well, add whatever they forgave you of to your taxable income, which will increase your tax liability for the year. And therefore, you're actually paying your marginal tax rate, multiply your marginal tax rate by whatever this amount says. And basically, you're increasing your tax burden for the year. So like I said, if you got forgiven of 6 grand, multiply that by whatever your marginal tax rate is. And like I said, we're just using numbers. 25% marginal tax rate. Who knows what it actually is for you? But 25% of 6 grand is what? Well, that's money that you're not getting back this year on your tax returns. I just wanted to mention that. Like I said, we're dealing with a very comprehensive class here. So, after all that said and done, debt collectors are supposed to report your account as paid with a zero balance. I should have included that over here. They should update your balance to zero. Collectors are not supposed to offer a pay for delete settlement. Okay, that would be violating their Metro 2 standards. They are not supposed to allow a pay for delete because in theory that's violating their, like I said, their standards for reporting debt. Uh, but some of them still do. Get any agreement in writing. If you talk to a debt collector, they will tell you anything. We've got free puppies. We'll send you one. Just pay this debt. They are not people that you can ever rely on their word. Get it in writing. Maybe I shouldn't have said the free puppies, but um, in two different verses, and we're going back to people, two different verses, it was referred to that those who are well don't need a physician, but those who are sick do. Jason's interpretation of that is if you're sick, go to a doctor. If you need legal help, which you very easily could need legal help, go to a lawyer. And if you need credit help, go to a credit professional. And I go on to say, and use whatever saying that you want in order to understand my point. Do you change your own oil? I don't. Uh, Long story short, I could go out, and for those of you who don't know, I drive an old Altima. Um, I saved so much money with that car. It's unbelievable. And we'll talk about that in the Wise Path to Wealth. But basically, I could go out there and change my oil myself. I could go down and buy the oil, then get changed and climb up under my car and do all of that. Then take the old oil down to the recycling place myself. Then come back and take a shower and scrub everything out from under my fingernails. Or I could take 30 minutes and drive down to an oil change place and give them, I think it's 60 or $70 to replace my oil. Which one do you think I go with? Now, here's an even more important question. Do you want to represent yourself in court? I hope the answer is no. Do you want to handle complicated credit problems yourself? If you do, I offer my best wisdom and I try to teach you as well as I can so that you can approach it with the best knowledge and wisdom that you can. But sometimes it's beyond your own personal capacity. And if absolutely nothing else, one of my friends, I taught him how to handle his own credit. You know what he said to me later on? Man, I just didn't want to mess with that myself. I paid somebody to do it and it worked. Okay. He knew how to do it. He just paid somebody else to do it. That's fine. So, until now, we've been focused on do it yourself. What you can do, what you should do. It's knowledge that everybody needs to know to manage their credit. What do professionals do? We're going to talk about what services are available and what each different type of professional is called and what you can expect from them. So, do it yourself side of it is building credit. Pay your bills on time, please. Avoid mistakes like don't open new accounts within 3 months of when you want to go apply for a home loan. These are simple things that hopefully you know by now. But what do professionals do for you? They can guide you through serious problems, and I've spent a lot of time emphasizing how serious this can be. They're specialists in the field of personal credit, and they can help you negotiate debt or get you debt relief. First group of people that we're going to talk about are certified credit counselors. Basically, what they are, non-for-profit professionals. They're compensated by creditors based on how much you pay back while you're in credit counseling. So what they do is they set up a debt management plan, which is also called credit counseling. Forgive me, it's a long video, and sometimes, especially toward the end, I begin to notice my presentation skills go down. But guys, stick with me. We're getting close to the end. Uh, Debt management plan is basically where they, well, in fact, we're going to talk about that here in a second. But they can assist you in disputing, but they usually don't offer disputing services. How do you choose a credit counseling organization? They usually they advise you on managing your money and your debts, and they can help you develop a budget and offer free education materials and um, workshops. They are usually certified and trained in consumer credit, money, and debt management and budgeting. Okay, so it's maybe I shouldn't say community service, but they are here to help you in budgeting and debt reduction. They're usually members of the National Foundation of Credit Counseling, so you can go and look them up at nfcc.org. They're best for people who are currently behind on debt or about to begin missing debt payments. And we're going to discuss specifically what debt management plans are in Lesson 8. We're going to save that for Lesson 8. Now, one thing that the FTC advises is to avoid organizations that push a debt management plan as your only option before they spend time looking at your financial situation. Sometimes it's easy to look at and realize that you're in bad shape and need a debt management plan. So credit counseling is it's like Chapter 13 bankruptcy, and we're going to discuss that in the next lesson. Chapter 13 is very helpful for those of you who are facing foreclosure or auto repossession. So see Lesson 8 if you're in that situation. So this lesson is about how to handle bad credit. So we're going to continue this discussion in Lesson 8. Now, it's a very real question that a lot of people have on their minds. Can you hire someone to fix your credit? Yes, according to federal law, according to the Credit Repair Organizations Act, it sets up a set of laws that govern credit repair organizations or credit repair professionals, credit repair guys, credit repair girls, however you want to say it, credit repair companies. This sets up a series of laws and practices that they must follow in order to be a legitimate credit repair practice. And I want to strongly emphasize to everyone that it's subject to the laws of your state. So, in other words, the federal government has certain laws that they have to abide by. Most states just mimic the federal laws, but some of them actually outlaw almost everyone except for attorneys. But the simple fact is that your state law could outlaw normal people from going and being credit repair professionals. You might actually have to have a lawyer dispute stuff for you. So, legal requirements. They can't make any misleading statements like promising to remove. In other words, I guarantee you that I will remove this. If it's accurate, current, or verifiable, they cannot do that. They cannot promise to do things like that or create a new identity for you. They can't ask you for a fee before services are performed. Now, there are services that they can do up front before they begin disputing, but basically they can't charge you for actually disputing things up front. And you must have a written contract giving you a 3-day right of cancellation. And all of these requirements aren't included in nonprofit organizations, so they don't apply to nonprofits. Most credit repair professionals are for profit. They usually charge about $100 a month, and that's plus or minus. If it's a little more, just decide whether or not it's worth it to you. Some people, it definitely is. Like I said, my friend, he seemed happy to pay somebody else to do this. Thanks for telling me how to do it, but I'm gonna get that guy to do it. Okay. They usually have a background in personal finance. They usually have a separate business entity, and usually, a lot of times, a lot of states require them to have a surety bond. And they thoroughly understand the state and federal laws regarding debt and credit reporting, as well as your state's laws. Like I said, most have a professional credit repair program to help them with disputes. In other words, it's more automated because they want to spend their time analyzing things instead of just writing letters and how to word those letters correctly. They find disputable discrepancies. They find violations of the Metro 2 reporting system. They can guide you through the disputing process, and usually it takes several months. I would say up to 6 months or more to allow them to do everything that they can do to get some stuff taken to get accounts taken off of your credit. So I wanted to mention, give them 6 months. So in my opinion, okay, and again, I interject my opinion on this because I'm teaching the class. They are similar to paralegals because of their knowledge of the legal process. Okay, so they're similar in that way, but they are not similar to paralegals because there is no requirement of direct supervision by an attorney or another licensed professional. So basically, what I'm saying is they are usually, most of them are very intelligent. They know the laws just like I do. They just don't spend as much time explaining all the laws because they spend their time disputing stuff. But the thing is, a paralegal is working for a lawyer. Credit repair professionals, most of them are not working for a lawyer. Just want to emphasize that. And some are better than others. Now, I want to emphasize one more thing when we're talking about credit repair organizations. Be very careful who you choose to work with because you will give them your social security number and other sensitive information. Anyone can start a business. There, in most states, there's no background check, there's no licensing. There's nothing to prevent anyone from any kind of whatever situation from starting credit repair businesses. And I will say very loosely that one of the credit repair groups that I'm a member of in Facebook, I went and looked them up. Um, their story is very graphic, and I thank them for being willing to present their story, but their story includes doing credit repair on one desk and selling weed on another. They cater to a very specific type of crowd, and that's their prerogative. But I want you guys to be very careful about who you approach to repair your credit. And also, are they trying to sell you a 609 letter? Enough said. Here's an example of a Facebook post. Um, guys, I don't know how much of this I really need to read out to you. If you followed along with me so far, if you're still here, you're smart enough not to fall for this. Reach out to me. I'm a credit specialist. I takes off negative items like student loans, bankruptcy, late payments, charges off your credit reports. No space, does credit sweeps. No space, credit score boost repair. Contact me for all credit services. I reply fast. And here's the key. I'm trustworthy. Please tell me I don't have to explain the problems here. So, With credit repair professionals, I'm going to end it with, in this particular thing with this. There's no requirement in Texas. Now we're talking about Texas. There's no requirement to prove competency or knowledge. Back when I was a real estate agent and mortgage guy, I had to take tests and licensing exams. On the other hand, they do classify credit repair as a credit services organization, CSO, and that requires registration with the Secretary of State as well as a surety bond. So you can go to, and this is a blow up of that little website that I showed you. You can go to a website here. Now this is just for Texas, state.tex.us CSO search, and look up the CSO name or their first, middle, last name. You can look up all of the registered CSOs within a certain city. That's how you want to find a credit repair guy. Go for it. But yeah, and by the way, if you want to sign up as a professional member on my site and you claim to offer credit repair services, I will look you up. Please don't waste your time or mine by being the guy who's not properly signed up with the Secretary of State or licensed in your particular state. Please don't waste our time doing that. Okay? So, when you want to choose a credit repair professional, find someone from a reliable source. Google them. Do they have a background or licensing in other financial services, whether it's insurance? Some states allow real estate brokers to be credit repair professionals. Are they a mortgage lender who also helps their clients repair their credit? Things like that, that makes them more reputable, but also ask if they have professional references. That's the number one thing that I would say. And like I said, you can always come to my website and try to find somebody local. You can go to our church groups, meetings, try to find someone. You can also go to, and I've listed the three major credit repair firms. This one right here may or may not still be operating when you're watching this video. I'm gonna have to watch and see, but there are major national firms. Look them up on the Better Business Bureau. Reputation's important, but results are what you pay for. This is the last slide on credit repair professionals. So they work for themselves or small companies. They look for industry experience in licensing in other areas, and go ahead and take a look at them on Google. But the thing is, if you can get a reference from a mortgage professional who's already worked with them on other accounts, that's what would matter a lot to me. If I was going out looking for a credit repair professional and my mortgage lender said, "Hey, you've got a couple problems here, but I know the guy to call or the lady to call to solve them," then that's a pretty good reference. As long as that mortgage professional has worked with them before and gotten good results, that's a pretty good place to start. Consumer Protection Attorneys, also known as FCRA lawyers. So, Fair Credit Reporting Act attorneys or lawyers. Okay? They specialize in credit law, disputing. They can sue under the FCRA, and we can talk about that later, but their fees are actually paid for by the people that you sue. So I will let them discuss that with you. And basically, what I would say is that you can sue them for up to $1,000 per violation plus attorney fees. So you don't have to pay them. So, and anyone who's listed on my site as an FCRA lawyer will give you a free consultation. Feel free to contact them. They also help out with debt negotiation and debt settlement. This is an actual lawyer who can sue for your rights. So, I just want to emphasize to everyone, debt collectors are dangerous. They have no problem violating laws. I could tell you stories. They will lie to you. They'll suggest or hint that you're being sued, that you're actively in a lawsuit and just don't know it yet. They love it when you don't know your rights. They seize on that. I talked to one, he's a former debt collector. He wasn't doing that anymore. He switched to driving trucks. Love truck drivers. Hate debt collectors. So he switched over. He came over to the good side. But he said, "Hey, look, it was my job to get money out of people, and yeah, I skipped over the part where I no longer have the right to sue them for an old debt." So, and he said it, I remember he said it in such a way like, "Yeah, I got this guy." So, there's still a little debt collector in him. It takes a certain kind of person to call people and lie to them. But always remember, it helps to have representation and someone who knows what they're doing. So, should you get help when you're trying to fix your credit, like I said, do you want to change your oil yourself? Do you want to represent yourself in court? That could be a very real end game to this. And do you want to handle complicated credit problems yourself? Hopefully, you'll think about contacting a professional. Rebecca, we're coming to the end of it, I promise. Rebecca is a cliche young person. I use stock photos in my class, but this is not obviously it's an actress. It's not a real person, but it's a example of a young college student building credit. I gave her one derogatory account that's actually legitimately not hers. Let's talk about her options. She can call the credit bureau, like I did, and inform them the account isn't hers. She can also go online and dispute on her credit bureau account that we created back in lesson 2, or she can write a letter to the credit bureau and do certified return receipt requested. That's always the suggested one. Let's take a minute and review this. This is the sample review, or the sample dispute letter that the Federal Trade Commission gives us. She can fill this out, do fill in the blanks, and enclose a copy of her Social Security and all of that, some type of bill or bank statement, and certified mail with return receipt requested. Now, if you're a Rebecca and this account legitimately isn't yours, usually it's just an errant account, an error. ERROR. I know I might not be saying that effectively to where you can understand, but usually it's just a mistake. That's the right word, mistake, that truly doesn't belong to you, and it'll come off your account with the first dispute, just like it did for me. Her credit report should be clean in 30 to 45 days. That's how easy it is to take care of Rebecca. If it's a problem that legitimately isn't yours, it should come off real fast. Mr. Robert, on the other hand, he's our cliche guy. He's mid-20s. He got out of high school. He got himself a good job, got himself a cool sports car, got himself a couple credit cards, and drove his sports car into the ground, wound up going into repossession, charged up his credit cards. Then they went into default. Maybe he lost his job, any number of things. So now he's got repossession on his account. He's got collections on his account. Basically, one of the questions that he's going to have is, should he dispute any debts within the statute of limitations? Can he be sued for an outstanding balance on his repossessed car? Should he attempt to settle any bad debt? Wow, that's a lot. Okay. For any debt that's not time barred, consider saving enough to settle it or make payments on it. Can he be sued for an outstanding balance on his repossessed car? Yes, but it is unusual. Should he attempt to settle any bad debt? Basically, if you've got any debt that's close to the statute of limitations, your primary concern is avoiding being sued and having a judgment placed against you. Like we talked about, that can be devastating to your long-term prospects. Lawsuits cost money for the debt collector, so they sue people who they have a high chance of collecting from. So before a debt collector has initiated the process involved to sue you, you can likely settle for about 40% of the outstanding balance. After a debt collector has filed a lawsuit against you, it's probably going to cost about 60% to settle. And you can settle a judgment after it's been entered against you. Now, I put about 80%. That really depends on who owns it and how willing they are to make a deal. But you can kind of see the point, 40%, 60%, 80%. So it just depends on where it is in the process. Now, should he attempt to settle any bad debt? Well, bad debt that's past the statute of limitations could stay on his credit report for 7 years after he first becomes delinquent if and has made no further payments. A settlement with removal should increase your credit score. So, in other words, if it's taken off your credit report. So, settlement alone won't do it, but pay and then dispute to delete, that could improve your credit score. And settlement with a zero balance should reduce your utilization ratio if it's a first party debt. So I know how complicated that must sound to everybody. Please just ask a professional. Should you begin rebuilding your credit with bad debt outstanding? Okay, so with no activity on your credit report, it looks like you don't have any concern for your credit and it might be less likely to recover the bad debt and then add in legal expenses for the debt collector. So if you are actively rebuilding your credit and making it look like it's an emphasis to you to get good credit, they might try to get a bonus out of you. Just always remember, if you want to start rebuilding within the statute of limitations, all of a sudden it looks like you've got some money, you might be suable. There's a lot of different factors to take a look at, and it really is up to you. You're my student and you have the knowledge and information, but it really is your life. So with positive activity on your credit report, you look like somebody who has income and wants to avoid a judgment. Consider focusing on settling any outstanding debt before trying to rebuild your credit score. That's an opinion, but it's something that you should consider. Now, again, we've got the gavel with a circle and a line through it. After the statute of limitations is passed and they can't sue you anymore, so the gavel becomes irrelevant, you need to decide what you want credit for and how soon you want it. You could wait for the debt to be removed after 7 years. So you can just, Robert could begin the dispute process. It takes about 6 months, like we talked about, to try to dispute everything off of his credit report. After the dispute process, you could always settle anything that doesn't get removed and then turn around and redispute it, trying to get it taken off. So, guys, seriously, this is where professionals can be the most beneficial. 6 months at $100 a month might be very cost effective for you when you consider how much time you actually need to put into appropriately disputing everything. This class is going to be about 2 hours long. The do-it-yourself disputing is a little bit less than that, but far more detailed and far more complicated. Yeah, it gets more complicated. So consider settling anything, then you can start rebuilding your credit, just like we talked about in lesson 4. In fact, we specifically addressed Robert's problems in lesson 4 and how he can recover. So it's going to take time and effort. Don't be afraid to speak to what we call a CRO, credit repair organization, credit repair professional, credit counselor, and get guidance. Like we talked about Charlie's, I intentionally gave him all kinds of problems to represent what people can actually go through. Think about what he's going through. He's getting a divorce. He's without a job. He's behind on child support. He's going through all these great difficulties. If you're Charlie out there trying to decide what to do, I feel for you. My heart goes out to you. Please remember, joy cometh in the morning. Life happens and sometimes things become very difficult. What we want to avoid for you is any type of court judgment, which could then easily become a burden for life and it'll affect everything in your life, everything in your family's life. Please don't ever get to a point where you wish you were passed away. Guys, that's not what God wants for you. In fact, if we need to read the entire verse for Psalms, and guys, I'm not a minister of any kind. Obviously, you can tell that by the way that I speak. I'm a finance guy. Give me a calculator. But any minister worth his salt is going to know this particular verse. Sometimes God is angry. sometimes we deserve certain amount of judgment, but we also deserve forgiveness. And God isn't going to want you to be with Him early just because you got into bad debt, just like the US laws don't want you in prison just because you got into debt. So God's anger is but for a moment, but His favor is for life. Weeping may endure for a night, but joy cometh in the morning. Giving this class as a professional and trying to be an educator, I feel a certain obligation to give you the best information that I have at my disposal. And I'm doing it as if I'm doing it to the Lord. Most of you will get that Bible verse. So I am trying to give you the words that God would want you to have when you're approaching your credit, and especially when you're approaching great difficulties. Lean not on your own understanding. And I really take this verse to heart. Sometimes God provides people to help you when you really need it. Our professional members participate in wise credit management to serve you by doing what they do best. And remember, you can watch these videos online, but you should also find a local meeting to come and share your difficulties and also your successes. Remember, we celebrate success. I tried to make it easy to find local groups and local professionals on wisecreditmanagement.com. Back when I was younger and just starting out, in fact, it was before I became a real estate professional, I found a house that was a really good deal, so I put it under contract. It was being sold by a couple that was getting a divorce and it needed a lot of rehab work. It was a really great deal, and I had a pretty big down payment. So I went down to my bank and they actually said no. And the guy who turned me down was actually kind of rude about it. Luckily, I didn't give up and I found a different bank who would do the loan for me. But while I was building this class, I decided I wanted to make it a lot easier for you to find somebody who can help you. All you need to do is type in some details about your situation, and you can have up to 3 professionals contact you about how they can help you. So, whatever your situation is, maybe you've got a rehab that you want to do, maybe you want to get an FHA loan, but you've got bad credit. Whatever it is, you can enter some details about your situation, and we'll help you find a wise credit professional to help get you approved. Well, what if you want to find a great deal like I found, but you're not sure how to go about doing that? Well, what you need is a buyer's agent. What you should do is enter in what you're looking for, and we'll help you find a local real estate agent that can help you find the deal that you need. Just type it in, and we'll help you find a professional that'll work for you. And of course, you need insurance, but really what you want is the best coverage on your home for yourself and your family. And guys, don't be like our friend Charlie and have a major health problem without life and health insurance. Especially if you're buying a home and you have a family, please contact an agent to get yourself proper coverage. And guys, if you have to make major decisions about your retirement account, especially if you're going to withdraw money for the down payment, please talk to a certified financial planner. Also, if you're a freelancer or some type of gig worker, please contact someone about getting a Roth or a self-employed retirement program started. And guys, if you're behind on any of your bills, maybe late fees are being added onto your account, maybe you're considering bankruptcy, please contact a certified credit counselor about a debt management plan to see if you qualify for Chapter 7 or if you need to prevent foreclosure or automobile repossession. It's time to talk to a bankruptcy attorney. On the other hand, consumer protection attorneys specialize in the Fair Credit Reporting Act and suing for violations, so they can actually wind up getting you money out of these companies that are harassing you. And credit repair organizations can help you by professionally disputing bad debt. Many of them are former or even current mortgage professionals who know the laws on disputing and how to get things removed from your credit report. And finally, if you need a reliable and inexpensive car like our class mascot, the Golden Nugget, then you should contact one of our dealers who can help you find what you need. And as always, we've got a little bit of homework. Now, this class has been basically covering bad credit. So if you have any bad credit, is it within the statute of limitations? In other words, can you be sued? Should you pay it off, dispute it, or let it remain the whole 7 years? We've kind of covered this pretty extensively, but remember, you've got the knowledge to hopefully help you make a better decision now. Remember to document your journey, and oh my goodness, is this very important for you to do if you've got bad credit. Always save all the correspondence that you send, that you receive. Please make sure and keep everything, write it down in the journal. You need all of that stuff in one place. And in the end, once you get everything taken care of, you'll have your own success story already written. Please join our community. I try to put us on all of the major social media sites. So your involvement your being able to share success or challenges could inspire other people. And obviously, always, if you are watching on YouTube, like and subscribe with a very tired but cheesy smile. Like and subscribe. It's been great having you. Do you know anyone who needs this information? Guys, a lot of us know people who have bad credit. Maybe you want to forward this class to them. We celebrate success and we always focus on our goals, not our obstacles. There's always going to be things in the way, but what we have to do is focus on incremental progress and applying knowledge to whatever problems we're facing. Lesson 8, we're going to do a quick preview. I've already told you guys what you can expect in Lesson 8, but we're going to do a quick preview of it. We're going to talk about what a debt management plan is and that it's good for people who are currently behind on payments. And that's usually set up by a certified credit counselor. We're going to talk about Chapter 13, bankruptcy protection. Always think about bankruptcy as using the law to protect you from your creditors. So it's good for people who are behind on debt payments and or facing foreclosure and repossession. Chapter 7, on the other hand, is good for people who are overwhelmed with debt and able to pass the means test. And Chapter 7 dismisses all unsecured debts. So you're always going to want to be grateful that that one's there. And remember, bankruptcy is protection and relief. It can take 2 years. In other words, we talked about Mr. Debt Stinks. And basically, he was able to close on a new construction home in under 3 years from when his bankruptcy was discharged. So it can take you 2 years to recover. But just remember, joy cometh in the morning. And remember, if you're Charlie, this next lesson is going to be to help you. Guys, it's been a long lesson. I'm so grateful if you stuck around to the end. I hope and I pray that you got a lot out of this lesson and that you can use it to enhance your own life. And I hope to see you in the next lesson. I hope that you don't need the next lesson, but if you do, it's here for you. Thank you. God bless you on your path.